Good evening, everyone. My name is Catherine DeVerne, and I have the pleasure and the privilege of being the 8th Dean of the Peter A. Allard School of Law here at the University of British Columbia. As I begin our program this evening, I'd like to acknowledge that we are here at the university on the traditional, ancestral, and unceded territory of the Musqueam people. And I stand, as I imagine many of you, as an uninvited guest on this territory. The acknowledgement that we give at the beginning of our public and private opportunities on this land is an important part of the university's ongoing project of reconciliation and engagement with the Musqueam people. And I think that it's fair to say that reconciliation is a very significant challenge for the university, but one that we are now at a point where we can begin to see the contours of what it might look like. And when we begin the term of the law school year, we really think about the legal importance of being welcome on this territory, but I do not have the qualifications or the ancestral authority to welcome you, so I just ask you to reflect for a moment about your time on this place. So I am very honored this evening to welcome everyone to the Walter S. Owen Lecture, and to welcome this year's lecturer, Justice Edwin Cameron of the Constitutional Court of South Africa. Justice Cameron, we're all very much looking forward to hearing from you this evening. This year's lecture is co-hosted with the British Columbia Centre for Excellence in HIV/AIDS, and I'm very happy to have this co-hosting arrangement and to welcome Dr. Julio Montana, who's the director of the centre, who's here in front for those of you who don't know him, and we'll have an opportunity later on to hear him say a few words. The Walter S. Owen Chair in Law was the school's first endowed chair, and it was established in 1982 in honor of our alumnus, the Honorable Walter S. Owen, and his many contributions to the legal profession, the community, and the university. The lecture is a public expression of the law school's wish to commemorate Mr. Owen and to thank the members of his family, the community, and the legal profession who made the contributions which enabled this chair to be endowed. It has been occupied over time, since 1982, by many distinguished and internationally recognized scholars and jurists, and so we're very happy to be continuing that tradition. And I'm very pleased that for this particular Owen lecture, I am able to introduce Amy Francis, who's Walter Owen's granddaughter, and who will be saying a few words this evening on behalf of the Owen family. And I'd like a special welcome for everyone in the family here, especially Daphne and Michael Francis, who are here with Amy. And my notes have not clarified for me, but I presume you're Amy's parents. Excellent. Okay. We should have clarified that in advance, but we got talking about refugee law and novels. Welcome and thank you for coming. Amy is a principal of Legacy Tax and Trust Lawyers, where she practices in the area of estates and trusts litigation. We're very grateful also that she's sharing her expertise as an adjunct professor here at the Allard School of Law. Amy got her Bachelor of Arts from the University of British Columbia in 1994, about the time of the 12th Owen Lecture, and she has a Bachelor of Laws from the University of Toronto. She's a member of the bar in both British Columbia and Ontario. She's practiced in the litigation department of national law firms in both Toronto and in Vancouver, and prior to joining Legacy, she worked as a tax litigator for the Federal Department of Justice, and that is both a very hard job to get and hold, and is a testament to her skill in her profession. While Amy was still a student, she spent a year at the Legal Resources Centre in Johannesburg, South Africa, working on test case litigation under South Africa's Bill of Rights, and so that is a particularly lovely connection to this evening's lecture. Please join me in welcoming Amy to the podium.
Thank you, Catherine. I'm very honored to have been asked to say a few words on behalf of the Owen family tonight. This is a special privilege for me. This evening brings together two things that are very close to my heart. My grandfather, Walter Owen, who was my inspiration to become a lawyer, and South Africa, a place where I spent a very special year as a law student in the late 1990s, and which in many ways still feels like a second home to me. My grandfather, like many others of his generation, saw massive social and political change on a global level over the course of his lifetime. He was born in 1904 in a jailhouse in Athlone, BC, where his father was a provincial police constable, and he rose to prominence in the legal community in Vancouver at a very young age. At 29, he was Canada's youngest county court prosecutor, and he went on to become a leader in our profession. He chaired the Canadian Bar Association, created the Foundation for Legal Research, served as president of the International Bar Association, and sat on numerous charitable and corporate boards. And he capped off his career with a 5-year term as Lieutenant Governor of British Columbia. Now, what stands out to me as a unifying theme of my grandfather's career is his unrelenting faith in the role of institutions and the rule of law. He was someone who believed that lawyers held a special place in society, not as business people or as entrepreneurs, but as upholders of the systems and values that underpin our democratic institutions. He was impatient with those who dismissed the role of lawyers in the world. He felt that lawyers had a critical role to play as watchdogs and guardians of our liberties. Now, my grandfather didn't live long enough to see South Africa's transition from an apartheid regime to a constitutional democracy. He died in 1980. But I can only imagine that the peaceful transition to democracy in South Africa and the adoption of a constitution containing an ambitious and far-reaching Bill of Rights would have been something my grandfather would have passionately supported. For the promise of South Africa's constitution is the promise of the rule of law and the protection of rights over the vagaries of political will. These are the principles that animated my grandfather's career, and I think he would be honored and humbled that a jurist of the stature of Justice Cameron was giving a lecture in his name. So on behalf of the Owen family, I'd like to express thanks to the Dean and the faculty for making this event happen, and Justice Cameron for coming all this way to our small corner of the world to share his wisdom and insight with us.
Thank you, Amy, for those very moving remarks. My name is Natasha Affolter, and I am the second shortest woman to speak here tonight. I have the particular pleasure of introducing Justice Cameron to you. And to introduce him to you this evening, I want to do first two things. I want to share some verbal snapshots of career moments that highlight Justice Cameron's internationally renowned work as a human rights advocate and AIDS activist. And second, I want to offer a glimpse of the humble yet profoundly inspiring man whom we have been privileged to have visit us here in Vancouver over the past few days. Justice Cameron's career has been marked by deep and far-reaching advocacy for justice, and particularly for the rights and destigmatization of people with HIV/AIDS. Justice Cameron became a member of the Johannesburg Bar in 1983, and his early work included the defense of African National Congress fighters against charges of treason, protection of land tenures against forced displacement, representation of conscientious objectors to military service, and fights for gay and lesbian equality. Justice Cameron worked closely within the National Union of Mine Workers on legal issues related to HIV/AIDS, including the negotiation of a comprehensive AIDS agreement for the industry with the Chamber of Mines. He co-founded a national AIDS consortium of non-governmental organizations, and he founded and directed an AIDS law project. Justice Cameron was also involved in overseeing submissions from the gay and lesbian movement to the Kempton Park negotiations to end apartheid. His work is often credited with ensuring the explicit inclusion of sexual orientation in South Africa's constitution. Justice Cameron achieved senior counsel status in 1994 and began his judicial career soon after the end of apartheid, with an appointment as acting judge of the High Court by President Nelson Mandela. It was around this time that Justice Cameron made public his personal connection to HIV/AIDS advocacy. In 1999, a young woman named Gugu Dlamini was stoned to death in Durban after disclosing her serostatus on radio, recognizing the ways in which his political and personal position could help combat inequality and stigma. Justice Cameron began to discuss publicly and openly that he was HIV positive. He drew particular attention to the utterly unaffordable price tag that was attached to antiretroviral therapies and the injustice of restricting these therapies to those with financial privilege. This advocacy would place Justice Cameron at odds with President Mbeki, whose AIDS denialism Justice Cameron has publicly challenged. Although President Mbeki would appoint Justice Cameron to the Supreme Court of Appeal in the judicial capital, Justice Cameron would not be appointed to the Constitutional Court for the remainder of Mbeki's time in office. It was in 2008, months into the term of a new presidency, that Justice Cameron was appointed to his current seat as Justice of the Constitutional Court of South Africa. In that role, Justice Cameron has made a significant impact in constitutional cases dealing with corruption, equality, and freedom of expression. In one such case, Glenister in the Republic of South Africa, Justice Cameron's decision held that the state had a positive obligation to create and to answer to an independent and effective anti-corruption force. As a significant defense of equality for the rights of South Africans experiencing poverty. Beyond his work as a judge and a human rights advocate, Justice Cameron is an accomplished author. He has written 2 powerful autobiographical texts, Witness to AIDS and Justice, A Personal Reflection. Now beyond the formal biography lines, I would like to say a few words about the guests that we have been so privileged to spend Vancouver. Justice Cameron, as many of you now know, has been extraordinarily generous with his time and with his interest in the law school and in the wider Vancouver legal community. Those who have spent time with him, law students, clinicians, staff, members of the Indigenous Community Legal Clinic, judges at the Court of Appeal, our own faculty members, and community members, all been touched by his humanitarianism and by his humility. Justice Cameron has allowed us to see the work that we are doing here at UBC through new eyes. He has inspired us by energizing us at a particular low ebb in our term, and he has inspired us by the example he sets. It is not only constitutional ideas and theories of constitutional interpretation that migrate when judges cross borders. By spending a few days with Justice Cameron, we can also see that moral courage and fearless advocacy can be contagious too. Please welcome
Justice Cameron. Thank you. Good evening, ladies and gentlemen. Very silent. In South Africa, we reciprocate. Good evening, ladies and gentlemen. Beautiful. I once tried that trick at the Inns of Court in London. It was a formal dinner, and I was the guest speaker, and I had to speak before the main course came, and I said exactly what I've said now in South Africa. African audiences are responsive, and I said, "Good evening, ladies and gentlemen." Dead silence. So I'm very grateful to you for being responsive. I'm really very honored and delighted to be here. Dean Deverne, Assistant Dean Natasha Affolter, and Ms. Francis, Amy, thank you very much for your eloquent introduction, and thank you too, Natasha, for your most generous and thoughtful words. I'm delighted to be here. I didn't know that you'd spent time at the Legal Resources Center. I'm going to be speaking a bit about the work that people like you and the Legal Resources Center do. So it's wonderful to feel a very personal connection, which I didn't know would energize my lecture here this evening. I'm also very pleased to be in Vancouver, which I must say is one of the world's most beautiful cities. I'm having a debate with my law clerk, Martin, and his family who drove up from Seattle, whether Vancouver is more beautiful than Seattle. And of course, for this evening, we'll agree that Vancouver is more beautiful. So, ladies and gentlemen, I've had the privilege, as Natasha has said, of spending time with a few of you. I also had the pleasure last week of being in Calgary. And I want to start by thinking of three issues that conjoin us as Canadians and South Africans, and specifically as Canadian and South African lawyers. And the first is that both of our countries experienced, you might want to say, suffered a colonial settlement that led to the subordination of an indigenous population and the establishment of a racial subordination and a supremacy of legal theory, a supremacy of racial governance and rule. And the consequences of that in South Africa were particularly acute, but they also had consequences in your country that you are still very, very much dealing with it. The second issue is the salient response not just of our two countries, but elsewhere in the world, internationally, in various legal systems, of a very specific issue, which is sexual orientation and gender identity. And as we argued in the constitutional negotiations that Natasha has referred to, sexual orientation and gender identity doesn't matter because everyone is gay. It doesn't even matter because a large number of people are lesbian or gay or transgender or intersex. It matters because it's a touchstone of our conception of humanity. That was the argument we made to the constitutional negotiators at an early stage in the 1990s. And this was the argument that they embraced that got sexual orientation explicitly in. I think it's a touchstone elsewhere as well. It's a touchstone in international organizations, international jurisprudence, and on my own continent, where there's still fearsome intolerance towards sexual orientation and gender diversity. And I think it's an important issue for legal conceptualization everywhere. And then the third issue is one that I'm very pleased to see is very live at Canadian law schools. I was very pleased when I was sent some links that showed me that it is alleged that some law schools want to produce social justice warriors, or SJWs. And I hope that you are guilty of that as well. Let me place myself very firmly in that debate. And of course, it's a legitimate controversy. It's one that I welcome, because at the base of the issue is the nature of law itself. Why do we have a legal system? Is it to entrench privilege? Is it to reinforce existing institutions? Or is it to tackle injustice? And even the very critical articles that I've read in some of the newspapers which are identified as being more right-wing than others, the people implicitly acknowledge that there's injustice in Canada. So the question is, what is the task of a lawyer, and what more specifically is the task of a law student and of a law school in addressing injustice? And those are the three themes that give the background to what I'm going to say tonight. And of course, the third issue was accentuated in South Africa by two further issues. The third issue about the nature of the law and its role in tackling injustice. Because under apartheid, we had the very acute issue that arose from that, which was, what is law? At what point does unjust law become no law at all? And that was a debate we had in the 1980s about our judges, should you accept office? And then, of course, the further issue which arises from that, which I've mentioned, which is what is the role of law? Is it purely to secure order, or is it to secure moral values through legal order? We had a long history in South Africa of racial subordination, which was specifically and minutely enforced through the mechanisms of the law. In great detail, apartheid was declared a crime against humanity in 1973, rightly, by the United Nations. But it wasn't declared a crime against humanity because it had been the most bloodthirsty or the most blood-drenched system of injustice. There were far more bloody forms of injustice on the African continent in the last 50, 60 years. You can include the South Sudan, where 2 million people have lost their lives since 1958, Democratic Republic of Congo, 4 million people. The Biafran Revolution in Nigeria, 2 to 3 million people. As we were becoming a democracy in South Africa, at the very time between March and May, in Rwanda, about 4,000 kilometers to our north, every day, every single day for 90 days, 10,000 people were slaughtered. Not systematically gassed with the mechanical efficiency of the European continent, but slaughtered with machetes by their neighbors, sometimes by their own family members. So we had an intense awakening to our law system. And the particular feature that gave rise to our constitutional transition was the fact that apartheid was embodied in law. It was a legal system brought by the Dutch colonists, much as the French legal system was brought to Quebec and the English legal system was brought to the rest of Canada. And they prided themselves on it. And that had the paradoxical result, which links me with Amy Francis here tonight, which is that Nelson Mandela, his partner Oliver Tambo, and other lawyers could use the interstices of the law to try to defeat injustice. Make no mistake, apartheid was a monstrous and pernicious system. And make no mistake that apartheid law was monstrous and pernicious. But because it took itself seriously as a system of law, and not just as a machete-wielding system of human subordination and extinction, because it was a system of law, there was space. There was space which led Mandela to fight the defiance campaign against unjust laws, to face a criminal court for his part in the defiance campaign, to face a criminal court in the treason trial that followed in the 1950s, to face a criminal court in the Rivonia trial that imprisoned him and most anti-apartheid leaders. But it also gave people like Arthur Chaskalson, whom I take it you met, Amy, a legal giant who became the first Chief Justice of the Constitutional Court at the very time that Amy was there in 1994. Arthur Chaskalson was appointed by President Mandela to become the head of the Constitutional Court, the court where I'm now privileged to serve. And the point of this is that after the 1950s, the 1960s, the 1970s, the 1980s, there was a flourishing industry of legal activism. Call them social justice warriors, Dean Deverne, Natasha, who saw the law as imbuing them with more than just a future or an opportunity to invest themselves with privilege, to reinvest the privilege of others, but as an opportunity to seek to create a more just society. And that gave rise to the Legal Resources Center, where I've mentioned Amy was, the Center for Applied Legal Studies on the Wits West campus, where I spent most of my years in practice, and many other legal organizations, Lawyers for Human Rights, many other flourishing legal organizations that sought to oppose apartheid through the law. And the result of that, when various geopolitical events occurred at the end of the 1980s, that made it possible for the apartheid government to accept that it had to reform its ways and to accept negotiation. The result of that was that the negotiating parties all agreed. There had to be a constitution, there had to be a Bill of Rights. Eventually, after quite a bit of debate, there was agreement on the Constitutional Court as well, which Arthur Chaskalson then headed. But the other important result was that organizations like the Legal Resources Center, like the Center for Applied Legal Studies, continued through into the democratic transition. A further result of the use by lawyers of legal opposition was a skepticism to governmental power. The oldest resistance organization on the African continent was the ANC. As a party, as an organization, as a governing party, it's under severe criticism, under severe skepticism at the moment for embodying criminally corrupt activities within its own hierarchy, until recently at the very highest level. But nevertheless, the ANC, through most of the 20th century, embodied a spirit of resistance to unjust rule, which again has carried through into our democracy, I believe, very, very beneficially. We have a skeptical population, one that is not cowed by power, one that interrogates power. And that became crucial to a story that I will now tell you. But let me revert to the question of the Rwandan genocide. At the heart of our Constitution, we have founding values, including the rule of law, equality, and human dignity, which are specially entrenched. They can't simply be altered by ordinary constitutional amendment. There's a special entrenchment procedure, including the supremacy of the Constitution itself. And in the preamble, there appears a vital word, which is diversity. And we recognized in the constitutional transition that diversity is important not only because it is vital to respect the innate differentness of humans in their culture, in their language, in their physical attributes, in their race, in their ethnicity, in their abilities, but that it's also instrumentally important to a flourishing society, to enhance and value and encourage differences and to allow people to flourish. But the third reason, of course, is that the history of Europe, the history of Africa, the history, I think, also of North America, shows the bloody, murderous, appalling consequences of a refusal to accept diversity. And the Rwandan genocide, at the very time that we were making our transition, is the best example of that. That is why we got this extraordinarily encompassing and progressive constitution. That is why I was privileged as a proudly and openly gay man who'd done anti-apartheid work as a lawyer, but had also fought for LGBTI rights under apartheid, to be appointed as a High Court judge in 1991. And it's a premise of our Constitution in many ways, in the language policy, which we officially have 11 official languages. Of course, English is the language of government, the language of courts, the language of legislation. But you are entitled, and it does happen, that people speak any one of the other official languages in our court, in other courts, in the legislature, and in government. So at the base of our Constitution is an important value which remains under threat south of your border, I hope not in your country, in the rest of Africa, and in too many places still in the world. It is a value which I hope your social justice warriors will fight for as well, because it is not one that in any jurisdiction in the world can be taken for granted. The other feature of our Constitution that was of great importance was that we included expressly in it social and economic rights. They're heavily structured. There's no immediate right to housing or healthcare or education or water or security or food or education. It's a right of access to all those important social goods. But behind them lies the important recognition, a vital recognition. And this is that the material conditions of life determine one's ability to exercise what lawyers call first-order rights. That you cannot have or properly enjoy a right of freedom of expression or freedom of religion or conscience or movement, or the right to seek work or to fulfill your human capabilities if you have an empty stomach. And that right played a crucial part in the great and first massive struggle in our country, the first test of our democracy. And that's where, even though I've only met him this evening, Professor Montaner and my paths crossed in what I've been reading for the last 20 or 30 years. This was AIDS. As we became a democracy in the first years of the 1990s, it became completely evident that we who had thought that we were distinctive from the rest of Africa to our north, from Uganda, from Tanzania, Kenya, Malawi, Zambia, Mozambique, that we were not different, but that the AIDS epidemic would afflict us with particular severity. And soon after democracy, we became the country in the world that had the most people living with HIV. It is still so. We have 7 million people living with HIV in our country. And one of the consequences of that shameful history of racial subordination and conquest and colonialism that I mentioned at the outset of my lecture was one of the issues that conjoins our two countries in ways specific to each of our countries. One of the consequences of that was that President Mandela's successor, President Thabo Mbeki, was unable to accept the etiology of AIDS. He felt it was too shameful to accept the learning of what he saw as white virologists. Do you plead guilty, Professor Montaner, to being a white male in North America? To come and tell President Mbeki after 400 years, ladies and gentlemen, of profoundly shameful exploitation, colonization, asset stripping, enslavement, murder, transportation of the black races by people like myself, by people like Professor Montaner, white males for the most part, that these same white males who had shown a prurient interest in black sexuality were now saying that the only mass epidemic of heterosexual AIDS anywhere in the world, in an epidemic that in North America, Western Europe, and Australasia manifested overwhelmingly amongst people like myself, homosexual men, was on the African continent a mass epidemic of heterosexually transmitted HIV. He said no. He went onto the internet. He was advised by goofy people, terribly misguided people in South Africa, and then by people from outside South Africa, people on the west coast of America, Professor Peter Duisberg, and other people who questioned whether there was a virus at all, whether if the virus existed, it was the cause of AIDS, and whether AIDS was not in fact an environmental condition. Of course, there's an important truth in that, because the condition, any illness, as public health experts have told us often, is conditioned by your social conditions. If you get the flu bug, you're going to get much more sick if you're living in an informal settlement with a leaky roof than you would if you lived in middle-class comfort and warmth. So that's true also of the HIV virus. It spreads more rapidly in conditions that are conducive to its transmission from one person to another. But it wasn't in that form that President Mbeki sought to maintain that AIDS was an environmental condition. It was in a much more radical, epistemologically revolutionary form, which was denying the etiology of AIDS entirely. And it was a terrible moment for our country. He took office in 1999, and within 6 months, it became catastrophically evident that he had been captured in some way by the doctrines of AIDS denialism. That was at the very time, as Natasha has told you, that I myself had spoken out about the fact that I was living with HIV. I was able to do so. I'd lived in silence, very much impelled and compelled and propelled by the terrible shame that still afflicts this disease throughout my continent. When I was diagnosed with HIV, I'd come out 3 years previously as a proudly gay man. I was speaking in a hugely repressive society for LGBTI equality, and then I found myself infected with a virus, which at that time was almost exclusively associated with homosexual men. My inner shame was overwhelming. I was about to say almost overwhelming. It was overwhelming, and I was overwhelmed for many years, overwhelmed into silence, overwhelmed into very, very profound, deep inner grappling. And then I fell ill 3 years after President Mbeki appointed me as a judge of the High Court. I'd hoped that I would be one of the tiny minority who, very, very tiny minority, a fraction of less than 1% who are long-term non-progressors, although most of even of those do eventually fall ill with AIDS. But I was not. Within 12 years, like most people in my condition, people of middle-class nutrition and benefits and comfort. I fell ill, terribly ill in 1997, but as Natasha said, I had access to antiretroviral medication. And within 2 weeks, I knew that what had been to me since 1986, the certainty of death, not just the certainty of death, but the certainty of a terrible death, had been removed from me, that my life had been given back to me. It was that, together with the death in December 1998 of Gugu Dlamini, a poor woman from a township in Durban who spoke out about her HIV and who was attacked by her own neighbors, that impelled me to speak out a few months later about my own HIV. I, who lived in middle-class circumstances in Johannesburg behind a palisade with the income of a judge, the income that enabled me at a time when the drugs were unaffordably expensive to 30 or 40 million poor black people on the continent, to afford the drugs, to start taking them, to have a turnaround, to gain my strength and energy and ability to work and to have all the faculties and joys of life again. It enabled me to speak out, and I did. And it was against that background that we now faced a president who said, these drugs are being pushed by people like yourself, sir. They're being pushed for more gain. You've exploited our continent for 350 years. Now you want to push these drugs upon us. Ladies and gentlemen, when I talk in the United States, I used to be able to take a cheap shot because President George Bush also held unscientific beliefs. I'm not going to take any cheap shots tonight. I think what is happening in Washington, D.C. is just too grievous and appalling for any cheap shots. But don't feel complacent. Don't think this is an African thing. It's right here. And what's more, I'm going to be very rude very shortly about your Canadian Supreme Court as well. And I know that I've got your support, Professor Montaner, because of a statement that you put out about that judgment. So irrationality, ladies and gentlemen, irrationality, disregard of scientific evidence, and ignoring the policy compulsions of evidence-based indications is something that is common even in your highest court, and I'll get to that with great relish in a few moments, Natasha. I was in Calgary last week, and that was the basis of my lecture, which is the two Supreme Court decisions that I'll return to. But let me first tell you about President Mbeki and his refusal to make these drugs available. Given the history of popular dissent in our country, the history of skepticism about power, the history of activism, the history of street activism, we gained a wonderful organization at the end of 1998, before President Mbeki took office, an organization that looked at the moral outrage that there were drugs that had been developed, partly by public money, at universities like UBC, at institutes like the NIH and the CDC on the east coast of America, and which were now patented by drug companies and which were exploited for financial gain. The TAC looked at this and said, this is morally untenable. And I joined their struggle to secure cheaper drug prices so that 30 or 40 million people in Africa would not die needlessly when drugs were available. That struggle was a titanic struggle. It didn't look as though it was going to be won, because the discourse of patent protection, of aggregation of profits for supposed research and development. I'm not a research and development skeptic. I believe that you do need capital aggregations for effective research and development. But in the case of AIDS, it was an intolerable argument. It was a moral iniquity of almost enormous proportions. The Treatment Action Campaign tackled that and won that battle. By 2002, brokered by the Gates Foundation, by the Clinton Foundation, there were major agreements between the major manufacturers of the antiretroviral drugs that they would be made available in much cheaper form, generically and through parallel importation agreements, so that people in Africa could have access to the drugs. That battle having been won, the Treatment Action Campaign had to face the more fearsome battle of a powerful, proud president who was elected in 1999 with a nearly 70% majority of the vote, and who made a centerpiece of his platform the renaissance of African pride, this continent that had been shamed by colonialism, by white settlement, by white concepts, including the concepts of disease, to treat people as diseased agents, as he called them. And the Treatment Action Campaign had to tackle that. And they used all the resources in the Bill of Rights that I've described. They used freedom of speech, freedom of association, freedom to gather, freedom of movement, freedom of the media. They used them to the greatest extent. And they used perhaps the most important right of all, which is the right of agency to enforce all the other rights through the courts. When President Mbeki wouldn't budge, they took him to court. And the court, presided over by Chief Justice Chaskelson, Deputy Chief Justice Pius Langa, 9 other judges, I wasn't part of that court at the time, gave a magnificent ruling which required President Mbeki to start making antiretroviral treatment available. It was a momentous ruling, and let me tell you why it is, ladies and gentlemen, because last night in Kenya, this is relevant in a way which should interest you. When we got our Constitution, looked at the Canadian Charter of Rights from 1982, and your Section 1 and our limitations section, your equality section in Section 15, our equality section in Section 9, have strong resonances. In turn, that grandparenthood had a grandchild in Kenya in the Constitution of the 4th of August 2010. Last night, in the face of a whole series of court orders, a Kenyan citizen with dual citizenship, I think it's a dual Canadian citizenship, was expelled from the country despite existing court orders. He was expelled in a drugged state, put onto an Emirates flight out of Nairobi to Dubai, despite a whole series of court orders. And we faced that. At the time of the Treatment Action Campaign judgment, President Robert Mugabe had started in the year or two before his monstrous campaign against the courts. He sent his thugs into the Chief Justice's court to climb over the bench and to shout down the Chief Justice while he was sitting there. A campaign of intimidation which put the rule of law, the very rule of law, at issue in Zimbabwe and led to its disintegration with catastrophic results over the next 10 years. That's what we faced. And for a few moments, a few weeks, it was uncertain whether President Mbeki would in fact follow the Constitutional Court decision. His health minister, a notorious person called Dr. Mantu Chabalala Msimang, who was here at a conference in Canada at that very time, during those very catastrophic years, said, well, the courts must sometimes listen to us. We know better than the courts on certain issues. President Mbeki, we later learned, sent his justice minister onto national TV the next night to say, we will follow this judgment. So it was a momentous judgment that secured the rule of law, and secured the rule of law because of young people of anger, young people of vision, young people of principle, young people who were determined to use legal rights, young people who saw a world of unaffordable medications, who saw a world of improperly used, irrationally exercised power, and said, this is not the world that I accept. It's the same force and the same power that we are seeing in the demonstrations south of your border across America, where young people say, I have a monstrous reality before me, and I will not accept it. I'm inspired by those young people. I hope many of them will become social justice warriors. Thank you, Natasha. 5 to 10 minutes left. Ladies and gentlemen, I will round up because I want questions, and we're still going to hear from Professor Montaner. It was our tradition of dissent, skepticism about power, the Bill of Rights, but also judges who were as willing as the Kenyan judges have been in the last week of the crisis of the rule of law in Kenya to enforce the Bill of Rights. And our judges prevailed. We had a president who humbled himself before a court ruling which he had every reason to loathe and to resent, and he accepted the power of the rule of law. Ladies and gentlemen, we still face enormous problems. We were, as I said in the introduction to this lecture, in the materials that those who have organized this lecture, Natasha's and the Dean's office, I said the AIDS came to afflict our new democracy, and it did. We are afflicted also by many other things, by corruption, by crime. I looked at a figure in the Globe and Mail this morning. 2,000 Canadians are killed every year in motor vehicle accidents. Our figure is 16,000, even though our population is just more than double yours. We have a very violent and comparatively dangerous society. We have about 16,000 road deaths, about the same number of murders committed every year. Very high levels of intimate femicide, very high levels, continuing levels of homophobia, with class specificity. If you're a black lesbian living in a township, you're at risk of rape, you're at risk of murder. If you're living in a middle-class area, your safety and security as an LGBTI person is very comparable to what it might be in Vancouver. So we are afflicted with many problems. But we had a transition recently, a month ago, which was constitutional. It wasn't coerced, as the transition was in the neighbor to our north, 2 months before, in November of 2017, where the army forced President Mugabe to resign. Our transition was a fully constitutional one, and President Ramaphosa has taken power. He was the head of the National Union of Mine Workers, which Natasha mentioned in her introduction. I worked with him when he was active there in the 1980s, and he understands the necessity for democratic listening. He understands the workings of democracy. He went from mine to mine, starting committees to get membership to which he saw himself as subordinated. He understands the responsiveness required from democracy. He's an impressive and capable person. Whether he'll be able to overcome the enormously entrenched corruption, criminally syndicated corruption at the very highest levels of our democracy is an open question. But I have every reason to believe that he has the skills and the guile and the competence and the resolve to do so. He is committed to social justice. So let me end there and let me invite your questions. I want to end off by saying, ladies and gentlemen, returning to my theme, which is that I think the mistake in the articles that I read, which take great offense at the notion that some of your law schools are creating people who are skeptical about law. The mistake made is that inculcating an attitude of skepticism implies a preconceived set of social outcomes. That's not true. As long as you concede that the law in Canada is unjust, it has to follow of necessity that your law schools have to produce lawyers who are skeptical about that position. And if that is all you do, and if you leave the rest, whether it be a socialist system or a more capitalist system, nevertheless, the essential premise of injustice means that the law has to be used to counteract privilege, to counteract improper application of criminal administration of justice, and to counteract inequality. That is what our countries have in common. We both have strong constitutions, we both have willing judiciaries, but most important, we have very active law schools, and we have young people who are prepared to fight that fight as warriors. Thank you very much. Thank you. So I wait for the questions.
Thank you so much, Justice Cameron, for your words, but also for so robustly inviting a question period, which we'll turn to in a few moments. Before we do turn to questions, I'm absolutely delighted that Dr. Julio Montana has agreed to say a few words to us this evening. Dr. Montana himself is a true international leader in HIV/AIDS, so it's not surprising that his path and Justice Cameron's have previously crossed. He is currently director of the BC Centre for Excellence in HIV/AIDS, and he has authored over 650 scientific publications in this area. Given that number, I almost omitted that sentence from these remarks because we do have a number of junior colleagues in the audience and a dean who thinks about research productivity all of the time. Dr. Montana's work has saved countless lives around the world. His major contributions include work in the 1990s developing combination triple therapies for HIV that transformed this fatal infection to manageable chronic disease. His more recent work has pioneered the concept of treatment as prevention. What began as a local Vancouver-based initiative focused on treating those living with HIV has become progressively embraced around the world as a way to control the epidemic. Dr. Montana's inspiring work shows us that research performed here in Vancouver can powerfully and incredibly quickly reverberate around the globe. For his life-saving research, Dr. Montana has received numerous awards and distinctions, and we welcome him tonight.
Thank you for the invitation. I feel a little bit like a fish out of the water, surrounded by lawyers. It's not very frequently that you welcome a phone call by a lawyer, at least in my professional role. Usually means trouble. So when your dean and associate dean contacted me and they indicated that Justice Cameron was coming, I didn't hesitate to say that we would be honored to welcome you and also to just briefly share the podium with you. I did not prepare any remarks because I wanted to base whatever comments on some of the words that you share with us. But I cannot help but remember the days early on in the development of antiretroviral therapy, which is where I come from, where we, to our surprise, found that treatments that we were experimenting with were able to shut down the replication of the virus. The virologist that was doing the work at the time for us was a colleague from Montreal, Dr. Mark Weinberg, who recently, a year ago, passed away under tragic circumstances, rather prematurely, I must say. And Mark figured out that in a clinical trial that I was leading, a combination of 3 drugs, in fact, one of them had been discarded by the Americans, nevirapine, we could actually suppress viral replication to the point that we could render people free of detectable virus. And that opened the door for the announcement in 1996 at the Vancouver International AIDS Conference that we were happily organizing at the same time. The announcement that there was a way forward and there was triple therapy. That changed everything, except that very quickly we realized that it didn't change anything because it was not reaching those that were most in need, as Justice Cameron just described. Mark Weinberg, who became a warrior, a social justice warrior, very much as many of us had to at the time, was appointed the president of the International AIDS Society around that time. And I'm sure Justice Cameron will remember, he and a number of us, I was serving in the governing council of the International AIDS Society at the time, had many trips to South Africa because we were organizing the Durban conference. And if my memory doesn't fail me, and I didn't check with you, but I believe that you spoke at the Durban conference, and you were very powerful. And I don't know how much impact it had on President Becky, but I sure remember that it had a tremendous impact on all of us and the rest of the world, because you told basically the audience that you were alive because you could afford that pill. and many people were dying because they could not, and that was an injustice that we could not tolerate. Mark Weinberg had met personally with President Becky, and he called him on his lack of leadership in this area, not once but many times. In fact, the whole conference, the Durban conference, was about trying to bring antiretroviral therapy to the south of the world, and South Africa in particular, among other things, of course. And I think to some degree, we succeeded in at least starting that flow of treatment to the south with significant success, not yet complete, but I hope that we are well on our way to see the dividends in very short order. We soon recognize, based on the work that we did here in Vancouver again, that a person infected with HIV not only can become free of symptoms and have a near normal longevity, but also be rendered non-infectious. That was counterintuitive at the time. We presented that in 2006. Unfortunately, at the time in which the new government took over, that was the government of Stephen Harper, and Tony Clement, the Minister of Health at the time, told me personally that we were ill-informed and ill-intended, that our work was promoting conducts that promoted HIV spread. And that started a very long fight that I'm going to spare you the details of. But nonetheless, it served as fuel for us to go elsewhere to try to get the traction that we needed to get for this strategy. And lo and behold, it happened. The United Nations embraced the strategy, WHO embraced the strategy, and today that strategy had led to the development of the 90-90-90 target that we crafted together for the UNAIDS as the way forward until such a time as a vaccine and a cure become available. But again, and resonating with some of the lessons that you heard from Justin Cameron, none of this matters if you don't have a legal framework that actually enables people to take advantage of the scientific advances that we bring to bear. And so, not because I don't like pointing fingers elsewhere, I'll point the finger to my own backyard, and I'll tell you that Canada has the rare distinction of being one of the countries that has the highest number of people being prosecuted indeed, for HIV exposure in the absence of HIV transmission. And that's something that we worry a lot, because having a strategy that works in terms of aiming to stop the epidemic, or nearly stop the epidemic, the legal framework is really not helping us, because it criminalizes people for the mere fact that they're having a normal love life at a time in which they don't pose any jeopardy to their sexual partners. We are delighted that the Attorney General, under the new government, has now developed a document that supports the stopping the over-criminalization of HIV exposure, as she declared. However, the provinces are still considering these documents, which is something that I'm here to ask you your help with, because we need to become an example for many other jurisdictions, including the United States and countries around the world, that continue to over-criminalize HIV. So I haven't used the word social justice warriors before, but I welcome that nomenclature. I learned something very important. I'm prepared to carry forward with it. Back when I went to medical school, social activism was viewed as a no-go place. I've been criticized for it many times, and as I like to tell my superiors, I won't name names, I'm honored to do this work, not just the scientific work, but the social advocacy that comes with it, because at the end of the day, if we don't enable the implementation of the scientific knowledge, nothing that we have done in the lab or in the clinic means anything at the end of the day. So thank you, Justin Cameron. Your work has been inspirational, and we are delighted to have you here with us. Thank you for the opportunity.
Very much, and I hope those few moments also gave you an opportunity to think of your own questions. Now I'm going to turn the mic to Justice Cameron, who I know is fully competent of running and chairing a question and answer period without my assistance.
Before I take a question, I just want to say that another link between Amy Francis and myself is through Arthur Traskelson and the LRC. I've been taking Navarapine for the last 20 years and 5 months. So thank you, Dr. Montaner. I owe my life in part to your work. Ladies and gentlemen, the other thing I admitted was to come back to my rudeness about the Supreme Court of Canada. Will you spare me 2 minutes to be very rude? I gave a whole lecture about this last week in Calgary. 2 decisions, and I honor you, Professor Montaner, you and your Canadian colleagues, who, like the South African scientists, have begged for rationality. In 1998, your Supreme Court gave a decision which, in effect, criminalized non-disclosure of HIV. This was not populist legislation as south of the border. 39 American states, almost 30 South African countries have got a criminal non-disclosure, and people are severely punished in the United States. Yours is a judicial invention by the justices of your Supreme Court. When I gave the lecture, one of the members of that Supreme Court, retired Justice Jack Major, moderated the question sessions. He did so with grace and with courtesy to me. And he said afterwards that the HIV science had changed and that information had changed. Well, it had. The Supreme Court had the chance in State versus Maybior in 2012 to change what was laid down in Courier, and it did not. In some ways, it accentuated it. It had every bit of HIV science before it. I want to say to you tonight that the outcome of the Supreme Court decision in Maybior is shameful. I don't use that word easily of a host country's Supreme Court. They disregarded the evidence before them. Professor Montaner and 72 colleagues put out a statement which, with much more Canadian courtesy than I've used tonight, said the same. It is irrational, ladies and gentlemen, at the very time that the Supreme Court was reinvesting criminal sanctions upon people with HIV who did not disclose their HIV, even when there was virtually no risk of any transmission. At that very time, that same Supreme Court was easing restrictions on sex workers, rightly, easing restrictions on the use of injecting drug equipment, rightly, was easing restrictions on doctors for assisted dying, rightly, was reinforcing the need to take into account Aboriginal history and conditions when sentencing Aboriginal defenders, rightly, was striking down in certain circumstances the effect of minimum sentences, rightly. 5 enormously progressive decisions over those very years when in Maybior it gives this appalling decision, appalling and shameful. Why? HIV stigma. That's the only answer. So I rest my case there. I've been as rude as you've allowed me to be. I think it is terrible, and I very much hope that the new Supreme Court under Chief Justice Wagner will follow the lead given by your homegrown Canadian courteous scientists and deal with that issue. Thank you very much. Questions, ladies and gentlemen? Yes, sir. I'm being welcomed in an African language.
Focus on South Africa again with a new president that's come in. How is the new president seen to focus on the diversity aspect of LGBTI rights compared to Mr. Zuma, who would just take a shower after doing what he had to do? It is something I think that South Africans are really concerned about. What is Ramaphosa's view on going forward basis to identify with the movement?
I think President Ramaphosa is fully committed to the Equality Clause. He's fully committed to diversity. I don't think there's any doubt whatsoever. Interestingly, and I didn't develop this in my lecture, the presence of constitutional equality for gays and lesbians has had an enormous effect over the last 24 years on public attitudes. More than 60% of all South Africans, township, suburb, rural, urban, black and white, support non-criminalization for people with HIV. On the other issue you mentioned, which is HIV stigmatization, we managed in the Law Commission to ward off what the Canadian Supreme Court did judicially and what many other African states have done legislatively, which is to target people with HIV irrationally for non-disclosure of their HIV, even when the risk of transmission is non-existent or nearly non-existent. And I believe that President Ramaphosa supports that fully. Thank you.
Thank you, Judge Cameron, for your very eloquent speech.
Can I just say that Dustin, like Martin Wilner here, is guilty of being a law clerk at the court. Martin is an American, and Dustin is a Canadian from Vancouver and from UBC, and thank you for both of your service at our court. Thank you.
Thanks, Judge. It was my pleasure serving there last year. My question's a bit of an aside with respect to the right to housing. You mentioned Treatment Action Campaign, which is one of the foremost socioeconomic rights decisions in South Africa. Another one is Grootboom. We in Vancouver are sitting at probably the hub of Canadian housing inequality, if not one of the world's housing inequality epicenters. And we now have a Prime Minister who has admitted to a right to housing, even though we don't have one in our Canadian Constitution, though some scholars, some like Margot Young at this school, foremost amongst them, probably would view Section 7 as housing rights inclusive. I'm curious, do you have any insights with our new transition towards a recognition to the right to housing and the certain proposals that our government or at the federal level have brought forward about a right to housing-based framework? Is there anything that you see from the South African jurisprudence that could be transplanted into Canada at this pressing time on housing inequality?
You have to have been in South Africa for 6 months to ask such a difficult question, I think. I don't have much wisdom, Dustin, but I want to take a slight detour and I want to make it even more radical. The big debate in South Africa now is that the ANC at its conference in December decided on a constitutional amendment that would enable expropriation without compensation. There were important qualifications. One was that it should not, as happened in Zimbabwe, occur with disruption and lawlessness and murder and pillaging, and therefore disrupt food security. The other is that it should not have adverse economic impacts. But the interesting thing about it is that the likelihood is that the constitutional amendment of enabling expropriation without compensation has a resonance here in Vancouver, because it might well be targeting absentee landowners, farms that are empty, farms that are unexploited, that are not farmed. It might be targeting people with multiple homes. Some of the house pricing in Cape Town has gone up enormously, very similarly to Vancouver, very similarly because of non-resident ownership. New Zealand has found a way of dealing with that in quite a radical way, which, when transported to South Africa, suddenly seems less radical. So I don't have a specific answer to your question about the Canadian right to housing, and I haven't followed that debate, but I think even more radically, the prospect of narrowly limited expropriation without compensation might help your Vancouver housing market. Thank you. More questions, ladies and gentlemen? Yes.
Hi, thank you so much for speaking to us, and I especially want to thank you for your candor, respecting very contentious issues. And my question has to do with that. I think that in Canada we have our judges, for a good reason, have a tradition, I think, of speaking mostly through their judgments, especially on contentious issues. And I'm curious what you would say to that instinct to as someone who's willing to make those statements publicly.
I agree with that tradition, I do. But I think on HIV and AIDS, it's been an epidemic of muteness. You've had the scientists, and they've been social activists, they've been beneficent, they've fulfill the Hippocratic oath. But the shame that I spoke about has meant that the epidemic has been largely silent. When I spoke out in 1999, I expected other people on a continent in which 30 or 40 million people are living with HIV, including political leaders, cabinet ministers, entertainers, singers, soccer stars, prominent people. I expected to be joined by them, and it hasn't happened. I'm still the only person holding public office anywhere in Africa who's spoken about my own HIV status. So I feel impelled to speak out. On other issues, whether it be education or housing, I speak through my judgments, and I therefore fully support this notion of judicial deference and silence.
Hi there. Thank you so much for your talk. My name is GB. I come from Nigeria. As a lot of people may know here, thinking about the African continent, Nigeria is probably the place with the second highest incidence of HIV in the continent, or people living with HIV. It is also a place that is very, very difficult to make any kind of progress in terms of treatment access and research. And actually in 2014, particularly around LGBTI people, there was a law passed making it illegal. You would go to jail for 14 years if you were openly gay, or if you were in support of people who were gay, lesbian, bi, and all that. And I was just wondering if you had any words of hope from your experience in South Africa and with the judicial system there in regards to a system that would actively prevent any kind of change and people seeking the support that they need.
Thank you very much for the question. I want to make 2 points. The one is an important point where I want to be heterodox as a lawyer, and perhaps Professor Montaner might have a view. The highest national prevalence outside the Bantu-speaking areas of Central and Southern Africa is in Nigeria, but it's 3.8%. We've been expecting a mass epidemic in West Africa. It's never happened. And that's why President Mbeki made the catastrophic mistake of linking the mass epidemic in Africa to blackness. It wasn't about blackness or about how black people have sex. It was to do with some specificity, possibly environmental. I suspect, entirely unscientifically, that it's probably also genetic. But I think that in Central and Southern Africa, if you are part of the Bantu-speaking peoples of Central and Southern Africa, you have the same susceptibility as the male partner in a receptive act of sodomitic intercourse. So it's an enormously high rate of transmission. It doesn't apply in West Africa. Over the last 20 years, no national prevalence has risen above 3.8%, which is most remarkable. And then thank you very much for raising, I thought it was the 2013 statute. Is it 2013 or 2014? January 2014. It's, what our questioner said is exactly right, ladies and gentlemen. It is perhaps the most fearsome homophobic statute ever adopted anywhere. And what our colleague said is literally true. If I go into Nigeria and say there should be equal rights for gays and lesbians, or there should be less persecution, the statute is so widely formulated that any support for lessening gay and lesbian persecution would subject you to a 14-year sentence. It is a monstrous statute, supposedly directed at curbing gay marriage. The hope, there is hope. And the hope is visibility. It's linked to the muteness about HIV in the sense that for millennia, we as LGBTI people have been silenced by monotheistic doctrine in the Talmud and in Islamic doctrines and Christian doctrines. And we've spoken out for the last 3 decades, and we've become vocal. We've been joyous. We were afflicted by AIDS, especially the gay male community. But that has happened in Africa, even in Nigeria. It's most difficult in Nigeria because of the strong homophobic traditions, which are to do, I think, with conceptions of masculinity in West African culture, which I know very little about, but I understand it's to be there. Nevertheless, people are speaking out in Kenya, in Uganda, under circumstances of enormous personal risk. Gay men, lesbians, transgender, intersexual, queer people are speaking out. And that changes things. Once you know that your own family members, that someone you know in the workplace or in your community or congregation is LGBTI, changes everything. We've seen that happen in your continent, both north and south of the border. And so I believe that the genie of LGBTI expressiveness and equality is out of the bottle in Africa. That was why that horrific statute was enacted in January 2014 in Nigeria. It's what I call an excessive reaction to unstable transition. We saw it in South Africa. A young man, just before the de Klerk announcement, went on to Stratham Square in Pretoria and shot dead 7 black people, a young white racist. And yet we had a transition. So unstable transition leads to excessively repressive responses. And I believe that in Africa, I'm not saying that it's going to be quick. I'm not saying that it's not going to cost a great deal in grief and persecution and imprisonment and torture and assault and even murder in Africa. But I believe that we will make progress and that eventually it is unanswerable that we will have LGBTI equality throughout the African continent. Thank you.
Thank you very much, Justice Cameron, for the words that have definitely moved us, certainly disturbed and irritated and angered us by some of the things that you've said, and certainly motivated us. And I think now we have a time over a reception and a glass of wine to reflect and digest all those emotions, and certainly to enjoy